Thank you all so much for coming to our last faculty speaker series of the semester. We're really excited to have Professor Smith come and talk with us, so thank you for being here. She's a professor of law and the director of the Cumberland Legal Aid Clinic. Just as a little bit of background, she teaches general practice clinic, evidence, and she also facilitates mindfulness events at school, which are much appreciated. Her areas of research include child protection, evidence, guardianship of minors, law and psychiatry, and legal history. Today she's going to talk to us a little bit about evidence in the new age of technology and how that can affect admissibility of evidence. So without further ado,
thank you. Thanks so much for the invitation. Thank you all for spending your lunch hour here. And I hope that this will be of some interesting use to all of you, whether you've taken evidence class or not. If you've taken evidence class, I hope this is useful review. And if you haven't taken evidence, I hope that this will get you really excited about taking evidence in the future. There are lots of interesting issues. The basic point of what we'll talk about today is to examine a specific iteration of a question that comes up in the law all the time, right? Which is, to what extent do we need to revisit, perhaps change some of the rules, some of the laws that we have in light of changing technology, right? So technology is happening all the time, and of course we try not to be too reactive, not to have our rules, our law be fairly stable over time. And so there's often a tension there, to what extent do we need to modify things. And if you look back over legal history, for example, the advent of the railroads completely transformed tort law, right? The advent of the automobile changed the Fourth Amendment law in many ways. We really had to modify that. So our question for today is the new technology that is really coming in and being a key part of the evidence that's being presented at trial. To what extent does that suggest to us that we need to revisit our rules of evidence and some rules of evidence specifically? I will say this is a very wide topic, so I'm just going to focus really on some specific questions that either courts have been grappling with or that I think are issues to watch and things that I encourage all of you to keep an eye out for. And really the question for us to consider is, how good of a job are our existing rules of evidence doing in courts today in light of the types of evidentiary issues that come up? So the name of the talk is New Tech Under Old Rules. So we'll start by just saying a few words about our old rules. And they are old. So the federal rules of evidence, as many as you may know, were enacted in 1975, and the Maine rules of evidence were enacted a year later, and they're modeled largely on the federal rules of evidence. But the rules, the underlying rules, are really much older than that. That enactment of the rules of evidence were really a codification of what had been in the common law for quite some time in Anglo-American legal history. In fact, Massachusetts still has not enacted rules of evidence. They still operate under the common law. They just have a helpful outline for attorneys that operate that way. So this is a photo from the Scopes trial in 1925. I love this picture because they are actually, I don't know if you can see it from where you're sitting, they're actually conducting the trial outdoors. So as many of you may know, it was a notoriously hot couple of weeks in Tennessee when this trial was happening. And as an example of some technology that they could have benefited from, perhaps in 1925, was air conditioning. They did not have that. And so they actually conducted some of the trial outdoors. But Dean Wigmore, so that's his photograph up there, he really was one of the leading historians of the rules of evidence, and he has been able to trace the origins of the rule against hearsay, one of our most classic evidence rules, back to the 15th century. We also know that as long as we've had the rule against hearsay, we of course have had hearsay exceptions. Once you have a rule, you have exceptions to allowing that in. And that is a picture of the Boston Massacre, and dying declarations were actually admitted at the trial of the British soldiers who were charged in relation to the Boston Massacre. And in fact, it was the dying declaration of one of the alleged victims that largely led to the acquittal of the British soldiers. So again, as long as we've had hearsay exceptions. and our discomfort with prosecuting people on the basis of hearsay is embodied in our Sixth Amendment, right there in our Constitution. We have some hearsay limitations of that. And many other concepts that really form the core of what we consider the evidence rules, concepts of relevance, concepts of impeachment, of limitations in character evidence, unfair prejudice. All of those have really been around for quite some time. We can trace them back decades and in some cases centuries. So a short version is our old rules are really pretty old. So what is our new technology? Well, when all of these rules were developed, when John Stokes was on trial and there were exhibits, the evidence that was presented consisted of documents. It consisted of people coming into court and offering testimony about statements that they heard, right? Things that they witnessed with their eyes, statements that they actually heard with their hearing. But now we have, with the internet, we have a lot of other kinds of potential evidence. So we have emails, we have texts, we have databases, we have web pages, we have wearable technology, between Apple Watches and Fitbits. All of these things are collectively known as electronically stored information, or ESI, referred to as ESI for short, and that of course can include social media. And some of the characteristics about ESI that distinguish it from what had been the classic evidence that was offered, whether it was documents or objects, is ESI can be easily created, destroyed, altered. It can reside in multiple locations at once. It can have multiple versions. It can be voluminous. And increasingly, we're aware of how easily one can create fraudulent, deceptive ESI through hacking or the use of deep fake techniques or simply impersonation. So this is a classic New Yorker cartoon, which is really from, in some ways, the early days of the internet, and it's become iconic. And the dog is saying to the other dog, on the internet, no one knows you're a dog. And that is, of course, one of the great values of the internet. On the internet, no one knows you're a dog. They don't know who you are. So there can be anonymity. There can be impersonation. And the other thing about ESI is that they become ubiquitous in trials, right? They're an absolutely core part of the kinds of evidence that we see in trials. One of the first things, and we were just talking about this in evidence class a short time ago, one of the first things that attorneys do now is they gather as much electronically stored information about either their client or about the opposing party early on. So, getting as much information on the internet, off of social media, and so forth. And also informing the client to watch what they post on social media, to adjust their privacy settings, because social media has become incredibly effective at capturing people in settings or making statements in ways that they would probably not want a judge or jury to see them. People can be amazingly indiscreet on the internet because they often don't really envision this coming up in a case. So I was just talking about this example with evidence students a short time ago. So this is a Twitter post from a woman who said, definitely knocked a cyclist off his bike earlier. I have right of way. He doesn't even pay road tax. Hashtag bloody cyclists, right? I mean, people will post the most amazing things that are on there. And as I said, it's really ubiquitous in trials now. Facebook in particular can be a source of a lot of information, particularly in family law cases. It comes up invariably. And not too long ago, a clinic student was doing a trial in a contempt motion, and the opposing counsel got up to approach our client with a piece of evidence, and she put the exhibit sticker on it. It was clearly a Facebook page, and I saw the judge's face just drop, like, oh, God, here we go again, with like more of the Facebook posts being come in. And then, of course, the client is like, well, I didn't really mean it that way. I was being ironic, right? So all of these things end up sort of becoming a sideshow in a lot of cases because it's there. These are things that would never have been coming in into other trials because no one would have captured their statements in quite this way. And as a result of all of these potential kinds of evidence, we now have to have a whole other set of discovery rules. We have now this thing called e-discovery, and a set of rules about the obligation to capture and preserve and perhaps exchange e-discovery. When I was in practice several years ago doing civil litigation, I remember we had a case that involved, voluminous telephone records. It was actually a case involving a telephone company. And, the attorney and I and the magistrate judge, we all just sort of scratched our heads like, well, how's this supposed to work now? And it was before they promulgated the e-discovery rules. And I don't know whether I feel fortunate or not, but, I got out of civil litigation before e-discovery because it's very complicated. It's something that you really need to master if you want to be involved. The other thing is, of course, the ethical considerations about gathering, capturing, preserving, deleting, manipulating somebody's online presence, whether it's your client or whether it is the opposing party. And then we have these wearables, and those are relatively new, and the types of evidence that could be potentially useful, either in discovery or perhaps in admissibility, is very tempting for a lot of parties. So we're just starting to see some examples of when this might come in. If any of you saw the article that was in Wired Magazine a couple of months ago, they actually charged someone with murder based upon the time of death that was picked up on the Fitbit from the victim. Because the time of death that was recorded from the Fitbit when her heart stopped beating corresponded with when the defendant was picked up on the surveillance camera, so it's technology number 2, on the surveillance camera of going into her home. And he was her 95-year-old father-in-law. And I was really curious to say, really, are we going to be able to convict someone? I mean, that was really the primary evidence. They could not find a motive for him. And he died not that long ago in pretrial detention, so that case is not going to go to trial. But something along those lines will come up again, which is, picking up body response data that is coming through on a wearable. In terms of the admissibility of that, I certainly wouldn't expect that there would be some challenge to it in terms of if it's sufficiently reliable or relevant, the risk for unfair prejudice, because people do think that this wearable data is very accurate, and it really has not been sufficiently tested, I think, for it to be admissible in court. With all of this new technology, there was a lot of anxiety, probably starting about 15 years ago, in terms of, well, what do we do about all this new technology that's potentially coming into court? And there was, I would say, some hand-wringing going on by judges, by attorneys. Do we need a new set of rules? So at the time I was on the Maine Rules of Evidence Advisory Committee, and the Supreme Judicial Court asked us to consider enacting a series of specialized rules about the admissibility of electronic evidence. And we examined the question and really couldn't come up with one that we thought was really necessary. We couldn't see that there was a particular need for it. And then in 2014, the Federal Rules of Evidence Advisory Committee actually held their annual symposium here at Maine Law. And the topic was the challenges of electronic evidence, right? So it wasn't just electronic evidence, it was the challenges. And again, there was a lot of concern about the extent to which, whether the rules were really holding up in terms of guiding courts and guiding litigants about the admissibility of all of these types of exhibits. In the midst of all this hand-wringing came out the Lorraine versus Markel American Insurance Company case, which was decided by Paul Grimm from the U.S. District Court for the District of Maryland. And Judge Grimm's opinion, even though it's way back in 2007, really considered still to this day to have been a landmark opinion. You don't see a lot of landmark opinions published in the FRD, but this one was, and it continues to be cited, and he did some additional writing about it. So if you look at the opinion, which I encourage you to do, you'll see it's lengthy. It was a fairly mundane insurance case, and one of the issues had to do with the scope of coverage, and one of the ways that the parties in their cross motions for summary judgment were trying to address the issue of the scope of coverage was through emails that have been exchanged by counsel. And so it was primarily an email case. And Judge Grimm, I think, was so dismayed by the inadequate ways that the attorneys in that case were acknowledging how this kind of evidence needed special kinds of treatment under the rules, that he wrote a 100-page opinion, which ended up being a step-by-step guide for attorneys and for courts of here's how you do it, right? It really is step-by-step. And he goes through what he saw are the key evidentiary admissibility issues for admitting ESI. And he was really making two key points in this opinion. One is that ESI is here to stay. Get over it is something he has quoted as saying to judges, like, it's here, we got to deal with it, we got to figure out how we're going to manage it. But he also, his second point was to provide reassurance to courts and litigants that our rules of evidence are just fine in being able to address any kind of admissibility question that's going to come up. Really, we don't need any special rules. And so if you read the opinion, it goes through questions of authentication, of relevance, of hearsay, of unfair prejudice, these very old classic rules that have been around for a long time, and he shows how they really map onto electronically stored information quite nicely. And he, once said that he was one of the speakers at our 2014 symposium, and then he was still saying the federal rules of evidence are doing, quote, a magnificent job of helping to guide courts and parties with respect to that. Now, just to remind you that the context for the Lorraine opinion was emails, right? That was the type of electronically stored information that he was considering in that case. And of course, when we think about email today as being electronically, we don't think of that as cutting edge technology anymore. We think of that as, the Pony Express, frankly, compared to a lot of the types of social media evidence that's coming in. So in 2007, when he wrote that opinion, the iPhone was launched later that year, so this was a pre-iPhone opinion. And at that time, Facebook had a mere 12 million subscribers. Now they have, what is it, 2.4 million or something along those lines, a significant amount. And the other thing about the Lorraine opinion that's interesting that he's pointed out and that I've noticed in reviewing all the case law that's emerged since then is that courts use Lorraine to as justification for both excluding evidence and admitting evidence. And Judge Grimm has said he considers it to be a completely useless opinion. All of this opinion that he spent all this time working on considers it completely useless because it can be cited for diametrically opposing views on the same issue. And courts, the case law is, as he's referred to it, really clear as mud on many of these issues. So I'm going to highlight what I think, just very briefly, three key questions that I think either have been the source of court opinions or likely will be, just for your consideration and also for you to keep in mind as you think about getting evidence admitted in practice. So the foremost one is authentication. That is where the action has been predominantly the number of cases that have been involved on the question of authenticating electronic evidence. Because of course at trial, for the most part, when you are introducing electronic evidence, you're not really introducing electronic evidence, you're producing a printout of something that was electronically stored at some point in time. A printout from a screenshot, from a database, from something else. And the question is it authentic? So just as a refresher for those of you, or as an introduction for those of you, all evidence, all exhibits have to be authenticated for them to be admitted. It's really the first hurdle that has to be passed. And authentication, the standard is really not that demanding, and courts emphasize this all the time. You really just need to produce enough evidence for a fact finder to conclude that the thing is what you say it is. That's what authentication is. You have to put in some kind of evidence that says the thing is what you say it is. And there are all different ways that you may be able to demonstrate this depending upon the kind of evidence. But the point is that if it's going to come in, there has to be at least prima facie showing that the jury can consider this to be authentic for what it is. And as I noted, there's all sorts of concerns about the authenticity of things that we find on the internet. So here is Ms. Williams' Facebook post that she was not participating in Wimbledon this year. Now, how do we know this was really Venus Williams' Facebook post about not going to Wimbledon? Here is Luke S., sending text to Obi-Wan. And how do we really know that this was Luke S's exchange with Obi-Wan? And then this is a more recent one some of you may have heard about. This showed up on Twitter. Dorothy posted, I do not know if this is going to tweet. I am talking to my fridge. What the heck? My mom confiscated all of my electronics again. And she was allegedly using her refrigerator to post a tweet. And there, I think, is still debate on the internet about whether that was truly a tweet that came from a teenage girl through her LG smart refrigerator, or whether it was some very clever advertising by LG, so forth. So how do we know that all of these things are authentic? Well, Rule 901 says we need someone with personal knowledge to authenticate it, but it doesn't necessarily need to be the person who created it, right? It doesn't actually need to be that. So that's where the challenge comes in. How do you get in somebody else's social media posting, somebody else's text message, somebody else's email that's not yours, and how do we do that? And Judge Grimm very optimistically said in Lorraine's opinion, this is an undemanding requirement. He said if you fail to meet this requirement, it's almost always a self-inflicted injury. He said you just need to do some careful planning. Take a look at Rule 901. And Rule 901 has a series of examples, non-exhaustive, of ways that you can get evidence admitted. So the examples not only are just someone with knowledge of the incident, of the evidence itself, a non-expert opinion by handwriting. Okay, that's not going to help us too much here. Comparison by an expert witness with handwriting. Again, we don't have handwriting here. Distinctive characteristics and the like. Now that one seems to be a little bit more useful in the electronic context. So something very distinctive about it that makes it clear that this was in fact Venus's Facebook post or something along those lines. Something about the context, something about the content. All of these may be potential ways that you can demonstrate that something is authentic. But what we're seeing from the cases is that courts really, potentially, if it's important evidence, if it's being offered in a criminal case against a criminal defendant, even though this is supposed to be an undemanding standard, the reality is that when it's coming to social media or other types of electronically stored information, courts are holding the proponents of evidence to a fairly demanding standard to really take comfort that it is authentic. And it's something that attorneys really cannot plan on. Cannot assume that they're going to be able to meet. They have to make sure that they can demonstrate to the court sufficiently the authenticity of it. Now, a lot of ways that we do this in the clinic is really just through the opposing party, right? So doing this on cross-examination, people will often readily admit to their Facebook posts, their text messages, their emails, and so forth. So that tends to be the most effective way to do that. But if there's a dispute, if someone says, I never posted that, I never sent you that, then you're going to really need to find something else to be able to get it in. So authentication is really the first challenge. The next area that I think is kind of interesting to consider is in the hearsay realm. So really two questions in the hearsay realm. One is whether something is a statement. So if you're going to try to classify an out-of-court statement as hearsay, the first thing that you need to be able to demonstrate is that it is a statement. We're only really worried about assertions of fact, right? An assertion of fact being excluded because that's when we're concerned about potentially remote testimony. So this is the definition of statement. For hearsay purposes, a person's oral assertion, written assertion, or non-verbal conduct if the person intended it as an assertion. And again, traditionally it was usually pretty easy to figure out if something was a statement. It would be something that they would say to someone else. It would be, a letter written with a quill, or by pen, or typed out, or something like that. That was a statement. But then we've got these emojis, right? So are emojis statements? Are all emoji statements? Are some emoji statements? So, to what extent are they sort of adding a tone, or are they actually an assertion of a fact? These are the ones that are about expressions, but of course, as you know, emojis, isn't there like a novel that was written entirely in emojis or something like that? There's a lot that you can convey with an emoji. And then the question is, well, how do you interpret it? And who interprets it? And who gets to argue what that emoji means? Do we need to call emoji expert witnesses? Do we need to have courts take judicial notice of what emojis mean? Do we have skirmishes at sidebar about what emojis mean, right? So And this can make a difference in terms of whether or not something's classified as statement and potentially excludable because it's hearsay. This is a question I have. I mean, usually photographs are not statements. But what if it's a photograph that's posted on Instagram? Like so this is somebody, why people post pictures of their meals, I don't know, but people do this all the time. So if you post a picture on the meal, I mean, are you making a statement, right? Is this a statement for hearsay purposes? I'm here, I'm eating this. You know, if this was a food poisoning case, right? Is this potentially useful for that? Are people going to skirmish over whether or not it's a statement? You know, in my youth, photographs were photographs, but now a lot of people consider photographs to be statements, to be assertions of facts, of things that they've done, of things that they think, of things that they believe. So I think that will continue to be significant. And even our wearables potentially could raise statement issues. Generally, machine-generated communications are not considered to be statements, because like I mentioned, it has to be something from a person. But there was already a case in Canada, I think it ended up resolving, where a woman tried to admit in a personal injury case all of her Fitbit data to show how limited she was in this personal injury case. So she wore her Fitbit everywhere she went, and she tried to show, oh, I can only do this, I can only go here, and I can't go running, and I lay on my couch all the day. I mean, can we consider that to be some kind of is that really machine-generated data? Is there some human assertion behind that? Again, it hasn't been tested in court, but I expect it will. And then the other hearsay context in which I think electronic information and social media in particular could be important is with two of the most common and most ancient hearsay exceptions that we have, in addition to the dying declaration. And so present sense impression and excited utterance. So these are, if your out-of-court statement meets these requirements, it is potentially admissible, notwithstanding the fact that it's offered for the truth of the matter. So a present sense impression is a statement describing or explaining an event or condition made while or immediately after the declarant received it. An excited utterance, which is related, and sometimes there's overlap here, is a statement relating to a startling event or condition made while the declarant was under the stress of excitement that it caused. So traditionally, when these were used to admit oral statements that were made by individuals, and generally the witness who was testifying about the out-of-court statement could provide some kind of corroboration about the event or the startling event or condition. They were often present there when they overheard it, or maybe they were on the telephone, right? But there was at least some relationship between the person who heard the out-of-court statement and the person who made the out-of-court statement. But of course now, these communications can be transmitted across continents simultaneously at the same time. So what does that do with sort of the assurance that we have about the reliability for that? And then a related question I have is, is this a present sense impression if it's a statement? Is this a present sense impression like I am eating this sandwich right now? And can text messages ever be excited utterances? Right? That's the way that we convey things. So, what would we look for? How would we know if something's an excited utterance? Traditionally, we would have testimony about how distressed the person appeared, have their tone of voice, that they were shaking, that they were red in the face, that they were shouting, right? This is what we know. So how do we figure that out on a text message? Do we look for, like, is there an OMG? It's like, right? And do we need to have something like this? Is this going to be sufficient foundation to admit something as an excited utterance? And then, of course, people are ironic sometimes when they use emoji and so forth. So it's not always easy to tell what that is. Courts have admitted some text messages as excited utterances, and I unfortunately the opinion doesn't provide enough details about why they admitted it. But there was a text message where the declarant was described seeing the defendant come home with bloody clothes a few hours earlier. So probably there were lots of explanation points or perhaps other things that were in that. But I think that that's something that courts are going to increasingly need to struggle with, because more ways that we're communicating information to people is through text message. So the last point I just wanted to make, and those of you who were in evidence last year will probably remember this example, is just to consider really how we bring all of these considerations together with a piece of electronic evidence that was offered in a case in Massachusetts a couple of years ago. So this guy named Odin Lloyd leaves his house in Boston in the middle of the night, and about a half an hour later, he's texting with his sister, and she asks him, he's texting with his sister, and he asks her, "Did you see who I'm with?" And she responds, "Who are you with?" And he says, "NFL, just so you know." And NFL, of course, was Aaron Hernandez, right? A former player for the New England Patriots. So Odin Lloyd responds this, and the next day, Odin Lloyd's body is found by a jogger in North Attleboro, Massachusetts, and he had been shot in the chest. And we know that Odin was a good friend of Aaron Hernandez, who lived a few miles away. And before the trial, or leading up to the trial, there was a real question about whether Aaron Hernandez was actually present at Odin Lloyd's death at that particular time. There was a lot of evidence about them certainly knowing each other and having some involvement with each other that evening, but there was nothing that actually placed him at the murder scene. So I just throw it out to all of you. What do you think? Do you think that the prosecution would be able to get this text message admitted under the rules? Or what limitations do you think that there might be? What challenges do you think the prosecution might have? And if you know the answer, don't give it away yet. But under the federal rules, do you think, what challenges do you think the prosecution might have to get that in? Let's think about authentication first, right? How might the prosecutor authenticate this as being actually a text message from Odin? How might they do that?
Phone records.
Yep.
They could look at how he texts every time. Like, I have a friend who, every time she sends a text message, she ends up like ellipses. So if it's from her, we know, like, you know, in the group chat, sorry.
Yeah, exactly. So something distinctive, right? So getting back to 901, so we're looking for something distinctive about it. Yeah, Ellie, did you have something?
Just phone records showing text sent between numbers, who owned the numbers.
But the question's going to be, right, I mean, you can show that the text actually happened, but the question is, was it Odin who was pushing the buttons, right? So, yeah, so certainly something distinctive about it. I mean, certainly the sister could testify this was the number that Odin and I always use. We've been using these numbers to text, right? So some kind of personal knowledge from her about it. So probably they can, assuming they do that, they could demonstrate the authentication. Is there a statement? Is Odin making a statement in here? And if so, what do you think it is? Think like the prosecutor. What would you like the jury to take from this text message? Yeah, what do you think?
Well, they're saying he was with Aaron Hernandez. They answered yes or no, and they want the jury to say yes, he was.
Yeah.
The truth of that.
And what do you think about the just so you know?
That would probably indicate some sense of, probably some aspect of present sense, sort of commentary, you know, maybe side issues in the past with Hernandez's temper or volatility. His sister's aware of that.
I mean, I know we all have 20/20 hindsight when we read those words, but, I mean, what did they say to you? Maybe Odin was a little worried, just so you know. This is, when we think about like those old letters that were sent off before somebody disappeared, just so you know, this person, wants to kill me in case you find my image, right? Just so you know. I mean, definitely part of what's implied is not only that he's with Aaron, but he's worried. He's a little apprehensive along those lines, and so forth. So maybe some of this is present sense impression, that he's actually basically saying, I'm with Aaron Hernandez, right? So that part may come in a present sense impression. Unfortunately for the Massachusetts prosecutors, because this wasn't in Massachusetts rules of evidence, such as they have them, they actually have no present sense impression in Massachusetts. So keep that in mind if you're taking the Massachusetts bar exam. So they could not get it in under present sense impression. And what about excited utterance? probably don't have, I mean, he could have been, kidnapped at the time that he's texting this, but we don't know that. We don't know if there's a startling event or condition. We don't know if he was under the stressor of excitement or of anything like that. So the prosecutors were not able to get this text message admitted at trial. Now, as it turns out, as the trial went on, it turns out there was lots of other evidence that came in that demonstrated that Lloyd and Hernandez were together in North Attleboro at the time of Lloyd's death. So this didn't end up being dispositive to the outcome. But it is an example of the challenges of electronic evidence. That this was obviously, it seems highly relevant to the mystery of who killed Odin. But some of the difficulties with getting electronic evidence admitted potentially could have changed the outcome of that trial. Just my final thoughts about this is just what I think is valuable about this new technology is that it really challenges to think about the reasons why we have the rules, right? Instead of getting very locked up in the text of the rules, do you have, handwriting analysis and so forth? Really, what is the thinking behind these rules? What's the rationale? Why do we have the requirements that we do? And I think that Judge Grimm's point is a good one, which is not to get too lost in trying to find something in the text that really speaks specifically to electronic evidence, but really the overall purpose and the goal of it. And frankly, some of our hearsay exceptions and some of our other rules may not survive the digital age. It may be that our modes of communication, our modes of creating information, of transmitting knowledge and so forth really do not make sense anymore with our rules, because they really are meant to reflect a very different way that we conducted ourselves. But I think it's good before we dispense with them and start thinking we need to start drafting a lot of rules that we really take a close examination of whether or not they still can potentially hold up. We don't need them too long. So I'm happy to answer any questions.
So in the Canadian Fitbit story, if she were to take that data and write it down every day, I walked 1.3 miles a day, would that then be admissible?
Well, it would be very different, right, in
Yeah.
terms of that. So, if we were in evidence class, I would turn around and I would say, what do you think? But I wouldn't put you on the spot about that. But yeah, I think we'd have a very different situation. That would be a much more typical type of situation that we would admit. So, yeah, it could be required recollection, for example, right? So that could potentially admit it. I mean, certainly diaries and journals, to the extent that people, sometimes they can be admissible as evidence. But the question is, once we transmit it to a Fitbit, does that change the application of those rules? So yeah, is walking around with a Fitbit, is that another way of doing recorded recollection? It doesn't seem to quite fit that well under them. But that would be an example. Yeah, please.
So could the Fitbit, a data sheet or whatever, could that then be used on cross, and we can say, you stated you walk 1.3, but your Fitbit says you walk 1.7. I don't know. Could it then be used that way, or is that
Well, I guess potentially. I mean, I think it depends on whether you're trying to impeach her with a prior inconsistent statement, if you consider that to be a statement, or if you're trying to impeach her by contradiction. If you're trying to say you said two different things at two different times, or if you're trying to say, in fact, you were lying about what your actions were on that particular day. I think that your second question is much more typical of how Fitbit data is being used, because it is being requested in discovery in civil and criminal cases, and it is being used to challenge people's stories about where they were. So there is a case from some years ago where there was a sexual assault complaint, and her Fitbit data demonstrated that she was not at the place where she says she was when at the time of the alleged assault. And not only did they dismiss the charges, but they charged her with making a false statement. So your example is much more typical of how Fitbit data is being used. Yeah.
In the text message scenario where they're trying to get that specific text message admitted, is it looked at individually, or can you try to submit sort of a larger portion of evidence as a whole that might support that, like other text messages sent near the same time that might help to prove that it was sent from him, or his location data, and maybe even Hernandez's location data from the phone to see if they were with each other? Does that help to pass those tests to get that admitted?
Yes, definitely. So sometimes using additional communications can be part of supporting the authentication of that. The concern that the court will always have is making sure that admitting that kind of additional evidence does not run afoul of any other potential evidence rules and potentially would need to be excluded. But yeah, sometimes that is the way that it is being admitted, is to show the overall context as opposed to showing it in isolation. Yeah.
I was wondering if there were any cases involving the Amazon Echo or these other home devices. I know they're very popular for, say, old people who are going to fall down and they want to call 911. So they have this set up specifically to call 911. Maybe that would be a liability issue. Does that come into evidence at all?
Well, I mean, 911 calls come in all the time. So to the extent that we can map what we already know about the admissibility of 911 calls onto an exchange with through an Amazon Echo, I assume it would be the same. I mean, 911 calls have to be authenticated, same exact way. So I mean, I think sort of in some ways getting back to your questions, the same type of thing. Authenticating 911 calls is not too demanding because we usually have the dispatcher, or we can have some self-authenticating certifications that will demonstrate it. If we add an additional layer of some kind of technology that enables the communication to happen at all from a particular location, there may need to be an additional layer of information that's provided if there is a dispute about the authentication. And I just should highlight a lot of this. I mean, not all of this stuff is disputed. A lot of this kind of information is probably coming in. Where we're seeing the case law generated is when there are disputes and there are concerns about authentication. I haven't seen any reported cases so far. It may be too early about Amazon Echo. There may be out there in terms of the dispute. But that's a great example of the type of technology that we'll want to see how well is that going to fit in with what we already know and what we already fairly readily admit without a lot of controversy.
Professor Petroselli told us that when he has clients, he tells them to be very careful about what they say in an email. Imagine an exhibit sticker on it.
Yes, that is great advice.
Yeah, so I was wondering, do you have advice for people going out in the world and with like an Instagram or a Facebook or a Twitter? Like, what are things like to say or do?
As little as possible. Really? Because, I mean, with these examples, you know, I mean, truly, again, we were just talking this a few minutes ago in evidence class, I mean, you don't imagine yourself as a civil or criminal litigant, right? So, and one thing about going through law school is, you know, it makes you completely paranoid, I think in very healthy ways. You will wish that all of your clients were as paranoid as you were. Because I think it's, yeah, I mean, the advice about don't put anything in an email that you wouldn't want to see, you know, have a court read, you wouldn't want to see an exhibit sticker on. The same thing goes, I think, for any text message that you send, anything that you post on social media. I mean, once you put it out there, it's out there. You cannot claw it back, right? And it's in multiple locations, and again, it's, you know, even if you think it's deleted, it's not really deleted. So that's why I say really as little as possible. I know that there are great values that people place on social media, but I do think people need to be, even something that seems innocuous or benign or ironic, I have seen in court far too often, again, these painful moments where people's, you know, silly Facebook posts or silly text messages said in anger from 3 years later can have a real impact because it's right there, it's in writing. It may not be in the writing, but there is nothing quite as vivid as your own words being used against you. It's very different when you have a witness recounting something that you said orally. It really does have a greater impact. So those would be my words of caution. Great, well, thank you so much for coming. I really appreciate it. And if you have any other questions about this, feel free to seek me out. My office is in the clinic, but I'd be happy to talk with you about evidence questions anytime. So enjoy the rest of